Because it's a sacrifice to come and do jury duty. So I thank them for coming in. And then I explain to the potential jurors, look, there are reasons why you might be excused. For instance,
I have to tell you, one of my heroes who has passed is a gentleman who I went to law school with, Judge Patrick Flanagan. And he had probably one of the best juror instructions that I've ever heard. And a lot of it had to do with how many people have fought and died for the right for all of us to sit in judgment of one another.
So a grand jury is not like a jury trial. It is basically the substitute or another route to take instead of a preliminary hearing. And there are many reasons that the district attorney might decide to do that.
What would you do, Judge De La Garza, if you had a juror that wasn't paying attention or even to the point of falling asleep? Good evening, everyone. This is Michael Gibbons. I'm the Chief Judge of the Nevada Court of Appeals. I'm appearing today on a panel with 3 other distinguished jurists. Tonight, our topic is jury trials, and some of you have been lucky enough to serve on a jury, and if you have not served on a jury before, I strongly encourage you to want to serve on the jury. It's one of the few areas that applies to everybody in the public. And these questions that I will be presenting to the panelists tonight are largely based upon questions from the public that have gone through the Our Nevada Judges website, where people are interested in finding out some of the intricacies of jury trials and why judges handle the proceedings in certain ways. So tonight we have Judge Maria Gall from the District Court in the 8th Judicial District in Las Vegas. We have Judge Melisa De La Garza from the Las Vegas Justice Court in Las Vegas, and Judge Shelly O'Neill from the Reno Municipal Court in Reno. Before we get into specific topics, I'd like the judges to introduce themselves in a little more detail. We'll start with Judge Maria Gall. Judge Gall, if you could explain to the viewers your basic duties and what qualifies you to do the work of a district court judge.
Thanks so much. The district court is what we call the court of general jurisdiction. And we hear civil claims of $15,000 or more, felonies. And then that's in the civil criminal division. And then in the family court division, of course, the family court hears family law matter. So that's just a very general overview of what the district court here does. My docket is an all civil docket, which means I presently do not hear criminal cases. I only hear civil cases. And just so that the audience knows, civil cases would include, for instance, your car accidents, your personal injuries, you might have a real estate dispute, or you might have a small business or a contract dispute. So I see a lot of those cases that come before me. What qualifies for me to hold this position? Well, I have over 15 years of complex litigation experience. I practiced with a number of firms. I have also been deemed qualified, but by what we refer to as our Judicial Selection Commission. I am an appointed judge, and so I went through this. Process where the Judicial Selection Commission, consisting of our Chief Justice of the Supreme Court, and then a number of people who are on that commission, a number of attorneys, but also a number of lay people. They review a very lengthy application that took me about 60 hours to complete. They do a background check. They call up people that you've appeared with, judges you've appeared in front of. They ask all kinds of questions about you, and then they nominate you to the governor for appointment.
What is the requirement in terms of being retained by the voters?
You have to, under the Constitution, appointed judges have to run in the next general election. For me, the next general election is actually this November.
Okay. Then you indicated that you are assigned to the civil portion of the 8th District right now. How was that determined? And what if there are criminal cases that need to be heard by jury trial? are you also able to hear those cases?
So I am able to sit on both types of cases. We are assigned our dockets through the pleasure of the chief judge, who is Jerry Weiss. I believe one of the reasons that Judge Weiss assigned me an all civil docket is because we have an incredible backlog of cases right now. And if I'm ever assigned a portion of a criminal docket, I'm completely comfortable taking on those cases.
Okay, the one final introductory question. What were you doing today before we started our show tonight?
Okay, so I am actually in the middle of a jury trial right now.
So you're rather busy, it sounds like.
A little bit.
All right, let's switch gears here and talk about the Las Vegas Justice Court.
So again, I'm Melisa de la Garza. I am a judge in the Las Vegas Justice Court. I preside over Department 15. I was elected for this position, and I've now been on the bench for 4 years. So I ran in 2018 and started in 2019. I currently preside over the battery domestic violence track, one of 2 tracks that handles battery domestic violence. And the battery domestic violence tracks, almost immediately after I started, our Supreme Court came down with the decision that people charged with battery domestic violence were entitled to a jury trial. So we had, and I have had, along with the other judge that had the other track at the time, Alana Graham, and now Judge Dotson, we were responsible for setting up the system to do jury trials in Justice Court, because normally we don't do jury trials. Justice Court is a court of limited jurisdiction, so we do civil up to the 15,000. After that, Judge Gall and the 8th Judicial take over, but below that, we handle small claims, and we also handle basically the entry of cases on the criminal realm. So when somebody's arrested, we do the preliminary hearings for gross misdemeanors and felonies. And then if they are charged with a misdemeanor, we'll usually do a bench trial. But in the case of battery domestic violence, they also have the right to a jury trial. Before I started in Las Vegas Justice Court, I had been a hearing master for the 8th Judicial for 8 years. Before that, I had my own practice for about 3 years. Before that, I was in the public defender's office. I did homicide cases. And before that, I was in the district attorney's office for 8 years, where I did probably between those two about 40 to 45 jury trials. So I have done jury trials as an attorney. Since now having jury trials in the Justice Court, we have done 2 in the Las Vegas Justice Court. We were ready for so many more. We really expected a lot of jury trials. We set up our system to be able to handle 5 or 6 a week. Even though we set them each week, like I said, we have had about 2 at this point.
Okay. So did you also play a role in putting together the bench book, which is the instructions for judges of how to conduct a jury trial?
We did. Actually, Judge Graham and I sat down and we gathered some of the jury instructions from the 8th Judicial and from, of course, case law. We also went back through some of just the procedures that we had to use being in the 8th Judicial, and kind of, to some degree, had to modify them to make them fit for the Justice Court. And for the smaller courts, like the municipal courts, we're not really set up initially to do jury trials. So we've had to do some modifications, but yes, we sat down. It took us a few months, but we did come up with a bench book for battery domestic violence jury trials.
So this essentially is to help judges that haven't done a jury trial before to properly conduct the trial?
It is, because in Las Vegas Justice Court, in fact, justice courts in Nevada, some of our judges have not had jury trial experience. Additionally, some of our judges in rural areas in Nevada might not even have legal training. They might not be attorneys in some of our smaller jurisdictions. So some of those judges now have the duty of doing a jury trial. So we tried to give them basically the a dialogue of sorts, just to give them a script, so to speak. Give them a script, give them the laws, give them some of the things to look for if they did have to conduct that jury trial.
Okay, and just a heads up, we'll come back to a question of what happens during a pandemic for a jury trial. So we'll save that for a little bit. We'll move on to Judge O'Neill.
Thank you, Judge Gibbons. I appreciate the opportunity to be here today. My name is Shelly O'Neill, and I am the Chief Judge of the Reno Municipal Court. I have served there for 16 years after being elected to the position in 2016. Happily, I'm on the ballot again, running unopposed for the same position. The Reno Municipal Court has 4 judges, each of whom, and we are the only court in the state of Nevada where each of the judges in our court has a specialty court. I'm proud to say that one of my proudest moments is that I created a veterans treatment court here at the Reno Municipal Court, the first misdemeanor veterans treatment court in Northern Nevada, and have been able to take a number of cases in our Veterans Court from across Northern Nevada, providing those rural jurisdictions with the opportunity to have their veterans placed in our program. And pretty importantly is the fact that the Fallon Naval Air Station is using our services for now active duty military people, because if they were convicted of any kind of a misdemeanor offense, it would be a career ruiner. My qualifications for this position are that I've been a lawyer for going on 45 years. I was the chief public defender for 13 years and tried about probably the same as Judge Garza, about 80 cases, including death penalty cases, when I was the chief of the public defender's office. I went on to run the antitrust division of the Attorney General's office for 2 or 3 years. I've been a prosecutor for the city of Reno for 2 or 3 years, and was in private practice with my husband for 16 years before being elected. I'm really happy. My court has been nominated and has received the accolades of being basically I say the best court in the state of Nevada. We've won that award on more than one occasion. And it's because I believe that each of the judges in our court work really hard to provide justice with a little element of kindness and respect that you don't often get in a lot of courts. That I'm really proud of the people that I work with here, from the clerks in the clerk's office all the way up to my colleagues here. We've created a homeless court called Community Court, run by Judge Christopher Hazlett Stevens, who is up for election. And we've convinced the Washoe County Library to hold that homeless court, community court there, because we found that many homeless people are afraid of the courthouse. Many of them sleep around the courthouse for security reasons in the night, but they're afraid to come in the building during the day for any kind of service. So Judge Hazlett Stevens and one of my colleagues who's now moved to the district court, Judge Tammy Riggs, got together, and they have acquired about 25 to 30 local providers, from Social Security, food stamps, Northern Nevada Hopes, which is a free medical clinic, Catholic Charities, Veteran Services. All of those things are provided to the homeless people in conjunction with, and this took a lot of convincing, but the Reno Police Department is a happy participant for all of those less serious misdemeanors like trespassing, littering, sleeping in a doorway. Those things, we found that to book a person into the Washoe County Jail is about a $350 cost to taxpayers. That's obviously the medical evaluations, all of the things that it takes to book a person in, including police officers' time. And so we've convinced the police officers, and I think that they were easily convinced, to ticket those offenders to the community court, where they appear every Wednesday morning at 8. They're provided a coffee and donuts. They're provided those services. The judge sits, and we have, through the city of Reno, if a person does not want the services, and we have a number of people who refuse those services, then we give them a vest and a lunch. The Washoe County Jail provides a box of free lunches, and we have a van that's been provided by the city of Reno. And we have my former head marshal, who has arms about this big. He is the driver of the van and takes people out to do community service immediately. So there's no gap in time for people to get their community service accomplished if that's what they're ordered to do. So it really is an efficient program. We have an average of about 50 people every Wednesday that we've kept out of the Washoe County Jail and out of the criminal justice system with those services. So we have some wonderful programs. We have a mental health court, we have a young adult recovery court, and a fresh start program. All of our judges have worked really hard to write grants, and each of us, I'm proud to say, have gotten about close to $1 million for each of our programs through the Department of Justice. So we are one of the few programs that can pay for testing. We have a psychologist in my Veterans Treatment Court. We have a team of 10, and we're being recognized by the governor's office in a couple of weeks as a leader in providing services to veterans. And I'm taking the whole team to Carson City.
I'm amazed to hear how many programs there are in municipal court. So are you ready to do a jury trial too in municipal court?
I'm ready. We actually, when the first ruling came from the Supreme Court, there was a limit of 6 jurors. And so we spent about $80,000 building a jury box for 6. And then there was a modification of that decision, and now it's a jury of 12. And what criminal defense lawyer would turn down 12 people when they had the opportunity? So I totally understand that, but we are in the process of rebuilding our jury box because of COVID and a number of other reasons. We have not had a jury trial here. I've had about 140 based upon my lifetime experiences in all areas, both federal, civil, and criminal, including death penalty cases. So I'm prepared to do a jury trial, and my other colleagues will come along. In fact, I want to thank Judge Garza and Judge Graham for the bench book, because it was really a welcome addition to the fraught that we had about the small jury box and judges not being able to understand what's going on. So we really appreciate their hard work in providing that resource to us.
Well, thank you very much. So let me get into some specific questions. In what types of cases is a person entitled to demand a jury? So Judge Garza touched on this regarding the battery of domestic violence. Is there any other type of case in justice court that would possibly have a jury trial?
In civil cases, they can demand a jury trial, but for the criminal cases, it's the battery domestic violence. And that basically came from our Supreme Court ruling in Anderson, where our Supreme Court found that because a defendant that was convicted of a battery domestic violence would lose his gun rights on the state level, that was a very important right, and they then found at that point that it is something, and it's the type of crime that somebody should be able to take to a jury trial.
So what about a small claims case versus a civil case that's seeking damages but less than $15,000?
So small claims cases don't have juries. Small claims cases are basically cases where you're looking at an informal type of proceeding. Usually you don't even have attorneys involved. If you do have attorneys involved, they can't even get attorney's fees.
Have you ever seen anyone request a jury trial on a civil case?
On our civil cases, yes. Yes, and in civil cases in justice court, we're back to what Judge O'Neill was talking about, a smaller jury. You can have as few as 4 jury persons or as many as 6, but you're not looking at the 12-person jury like you are for the misdemeanor crime.
All right, thank you. Judge O'Neill, are there any options for a jury trial in municipal court other than the mandatory battery domestic violence if a person makes a written request in such a case?
No, there are none. So we only handle misdemeanor. There's no civil cases that are heard in the municipal courts. It's all criminal, and the only criminal case that is allowed to request a jury trial would be a domestic battery case.
Okay. All right, in district court, if a criminal case comes in, it's automatically set for a jury trial, and to not have a jury trial, then both the prosecution and the defense has to agree, and the judge has to agree, it'll be a bench trial in a criminal case. Now, in a civil case, it's a completely different situation. So, Judge Gall, how do you see it on civil cases? Are you receiving jury trial requests, or are they bench trials, or both?
On civil cases in district court, I'm mostly seeing demands for jury trial. And let me address that for a second. Because I think Judge Gibbons touched upon a really good point. In the civil context, you have to demand a jury trial, and that is a formal process. You actually have to ask for it, and typically you have to do it through a writing, and you have to do it after the initiating pleading to the case. So if you are the plaintiff, you cannot demand your jury trial in the original complaint that's filed. There's also a timing element. In order to timely invoke your right to a jury, you have to make that demand before the court first sets the case for a trial. And this is really important because I have had cases before me where the parties, one party or another, sat on that right to invoke their right to a jury trial. They sat on that right, sometimes almost all the way to the end of the case. And you've basically lost your right at that point to invoke a jury trial. So that's one thing that's very important to keep in mind, that you not only have to demand it after the initiating pleading, but you have to do so in a timely manner. And as I was saying, I am mostly seeing demands for jury trial. However, I am actually surprised that there is a not insignificant number of requests for bench trials, including through stipulations of the parties. I don't know. I haven't looked at the statistics. I don't know if perhaps there is an increase in the number of requests for bench trials, because I can get a case to a bench trial a lot of times much easier than a jury trial. And here's the reason. For a jury trial, I need continuous days for the most part, right? So if it's a 5-day trial, I need 5 straight days. That doesn't mean I can't have the weekend in between them, although I prefer not to have a weekend break up a 5-day trial. But for the most part, I like to make it continuous, not counting weekends. With a bench trial, because it's me, the judge, sitting as a fact finder, I can break that up. So for instance, I do have a bench trial that I think is going to go at the end of the month. It's set for 2 days, but because of my schedule on those 2 days, I thought to myself, and I conferred with the parties, that we may need to add a third provisional day. Well, that third provisional day is over, I think, 10 days from the 2 originally scheduled days. So there's a lot more flexibility in having bench trials. And so this is a little bit of speculation, but I wonder if the amount of bench trials and stipulations to bench trials I'm seeing from the parties is because some of these cases have been sitting for a while from the backlog, and they know that if they stipulate, they can at least get the case to trial.
So what about the legal basis for getting a jury trial? Because not every case has one. So you've explained that a party has to demand it in a civil case. Many people forget that the United States Constitution and the Bill of Rights, in the first 10 amendments, we have an amendment that deals with criminal jury trials. Everybody knows about that, but there's also one that deals with civil jury trials. And so why is it that civil jury trials aren't automatic? And then how about the short trial program? And if you could briefly explain that, and the number of jurors. And we will lay out for the viewers tonight that there's different procedures for every type of trial.
That's a lot of questions. So let me take them one by one. And I encourage, my colleagues here to jump in. But one of the questions you're absolutely right, Judge Gibbons. There is a right to trial, even in the civil context. But my understanding, and someone can correct me if I'm wrong, is that you still have to invoke that right. Just because the right is given to you doesn't necessarily mean that it doesn't have to be invoked in the civil context. And so we look at this and we look at the, and we have the rule of civil procedure. This isn't something that's just, made up, but there is actually a rule of civil procedure that governs the obligation, I'll say, to invoke the right to demand a jury trial in the civil context. In the short trial program, and if I've forgotten the question already, Judge Gibbons, please remind me. But in the short trial program is a little bit different. You can take your case, including cases that don't necessarily have to go through the short trial program, in the short trial program, and I'll give you an example here in a second, where your case is heard by a fewer number of jurors than in what I would call a case that's in front of, that would be in front of me. And I say that with a little asterisk because I can still hear a short trial case. And that's what I was referring to. I actually have a case that's going in November where the parties stipulated to follow the short trial procedures, but they wanted to have the case heard in front of me. It's going to take a day. That's typically how long, I believe it's, if I remember correctly. The parties get 3 hours each to present their evidence. But it's going to take a day or even less than a day to present all that information to me and to the jury, and then we'll render a decision. And I know there were a lot of questions, and I apologize if I skipped over one, Judge Gibbons.
I think you pretty much handled it. Part of the question is how many jurors are there in a jury in a short trial program and in a normal civil case, and then in a criminal case, if it's in justice court, municipal court, or district court?
So if I'm going to answer it for district court. So for district court, there's 12 jurors in a criminal case. For a civil case, there's 8 jurors, although a lot of people don't know this. Under the rules, the parties can stipulate to less jurors if they want to. I have not yet had any parties stipulate to less jurors. And in the short trial program, there's typically 4 jurors.
Okay, all right. So Judge De La Garza, you've mentioned it, and Judge O'Neill briefly mentioned it too, about the 6-person jury trial in justice court, then the 12-person, and could we be going back to a 6-person again?
Well, we were a little surprised when we went from a 6-person jury in the criminal battery domestic case to the 12-person jury. So I don't know if the Supreme Court is headed towards changing that and going back to a 6-person jury. You would probably have more knowledge about that.
You can see, the viewers can see the procedures are different, and generally speaking, the Constitution requires a jury in a criminal civil case, but states and courts can set rules, and then unless it's overturned by a higher court, those rules are going to be followed. And it's gone even as far as not requiring unanimous verdicts. Now, Judge O'Neill, you have a long career. Have you ever seen a criminal case that didn't require a unanimous verdict, or a verdict of less than 12-0 or 6-0?
No, if one of the jurors in the cases that I've tried didn't agree, then there's a mistrial and the case is retried. I do want to remind you, one of the interesting things about the new rule about 12 people in domestic battery cases is that you have the option, the lawyers have the option of going with 6. But as a former criminal defense lawyer, why would you opt for 6 people making the decisions when you have a better chance of finding somebody who is contrary in a group of 12? So that my experience is I've never had anything other than a unanimous jury. I have had many mistrials, but nothing where there was the finders of fact were allowed to proceed without a unanimity.
So what is the constitutional rule in that regard? Could the legislature do something different between 12 and 6 and unanimous and not unanimous?
I don't know. I would have a lot of skepticism about a less than unanimous jury in a criminal case. I know the British system allows less than unanimous decisions, but I've not seen that here in the United States. At least I've only practiced in the state of Nevada. And I've never seen anything in a criminal matter less than unanimous.
Right, let's then contrast that to a civil case. Judge Gall, what do you see as the procedure in a civil case in contrast to a criminal case?
Well, you don't need a unanimous verdict in a civil case. And I think that makes sense. We're getting a little bit into the, area of policy here and why certain laws are created. But in a criminal case, obviously, we're thinking about you're talking about the loss of liberty effectively. And so in my own view, you would want a unanimous verdict because of the standard, right? No reasonable doubt standard, but also given the implications in a criminal case of where you're potentially, if the jury returns a guilty verdict, you're taking away somebody's liberty and their ability to live, freely. In a civil case, what we're largely talking about in a civil case is you're talking about money at the end of the day. I mean, there is, declaratory relief, which, typically doesn't go to the jury. And then there's, injunctive relief that people might request, right? But at the end of the day, most of the cases that are going to the jury, what we're talking about are damages and money. And so we're talking about something certainly in a different field than the loss of liberty in a criminal case. And while I certainly understand that some litigants may feel that in a civil case, a particularly large award, or if that they've been damaged, that the repercussions can be significant. There is still a distinction between those cases and the gravity of what those cases are actually deciding.
Hey, thank you. Before we leave this topic, I wanted to briefly mention the family court and the juvenile court too. So in Nevada, in the family court, there is no right to a jury trial. However, a civil complaint is filed, even for divorce. A civil complaint can include other issues, such as an allegation of battery. And if there is such an allegation, then isn't there a right to a jury trial? Now, I don't know if any of you have ever seen that before because you're not doing family court, but I actually saw that happen when I was a district court judge, where there were allegations of battery, and there was a question of whether we were going to have a jury trial in conjunction with a divorce proceeding. Have any of you ever heard of that?
I do not do family law. I have not heard of that. But what would be the standard at that point? And again, what would be the repercussions?
Well, there would be a question for the judge is the case going to be heard at the same time, or do you the legal term bifurcate it into two different parts? So a judge hears one part and a jury hears another part. But we often see cases on appeal where somebody is charged criminally with domestic violence, and then that's brought up in a family case when there are children at issue, because there are special rules that apply to custody decisions if there's domestic violence. So it's really important as to what happens in the criminal proceedings, because it can affect the family court proceedings.
Absolutely.
And in fact, we just had a case very recently where the claim was the family court proceeded with the trial before the criminal charge was resolved. And one of the parties was complaining on appeal about that the family court should have waited till the criminal case was resolved. Have you ever seen that argument in a criminal case? Well, there's a family case going on, so we either have to go faster or slower.
Well, in battery domestic violence, they often do overlap. Usually where we see a lot of the issues is in a protective order situation against domestic violence and the battery domestic violence. But when there's child custody, of course, often we are asked to try and proceed with our case or do certain things so that the family court will have our ruling before they proceed with some of their hearings.
Okay. Judge,
Well, and Judge Gibbons, the other thing that we have to take into account is the person who's the perpetrator's constitutional rights relative to Miranda and their Fifth Amendment privilege. In a civil case, they couldn't be forced to testify. So any smart lawyer would bifurcate that criminal matter out. So they're not placed in a position that they would have to inculpate themselves in testimony.
In the case I was referring to, there was a Fifth Amendment argument in the appeal, and the family law case went first, and the person that was charged with domestic violence waived their right to remain silent and took the stand in the civil case, but still claimed on appeal that her Fifth Amendment rights were infringed. But the court did not force her to take the stand. She voluntarily took the stand. So that argument was not successful.
So in justice court, we are the court that handles not only the misdemeanors like the battery, domestic violence, but we handle the beginning cases for felonies and gross misdemeanors that will later end up in the Judicial District Court for jury trials. So if you're going to have a jury trial in district court, you're looking at that beyond a reasonable doubt, and that's when a jury is deciding whether somebody is guilty or not guilty. But before a defendant gets to that stage, down in the lower court, our court, the justice court, somebody has what's called a preliminary hearing. And at that hearing, the standard is just slight or marginal evidence that a crime has been committed and that this person committed that crime. And then if that burden is met, it can go over to the district court. Well, in some instances, the district attorney's office might make a decision that they don't want to have a preliminary hearing and they'd rather go to a grand jury. So a grand jury is not like a jury trial. It is basically the substitute or another route to take instead of a preliminary hearing, where you're just hitting that slight or marginal evidence for something to be bound over for that jury trial. But a grand jury does go in front of a jury, and it's in secret. And there are many reasons that the district attorney might decide to do that. They might do that if it's a very sensitive matter. Maybe they don't want the victim to have to testify in a public hearing, because a preliminary hearing is a public matter. There might be certain witnesses that they want to be kept secret. So the grand jury is a secret hearing. Those juries usually sit, I think they sit for a year now. But they are people that come from our community like you would for a jury trial. However, they don't just hear one case and they're done. They sit for an extended period of time and listen to multiple cases depending on what the district attorney decides to present.
Did you ever take a case to the grand jury when you were a prosecutor?
I did, yes.
Okay. And we were talking about unanimous verdicts in a trial jury. Now, of course, a grand jury is not deciding if somebody's guilty, only if there's enough evidence to hold the person for trial. So there's no requirement of unanimity in a grand jury. Is that correct?
Correct.
Right. And I don't know how many jurors that you dealt with when I was involved with the grand jury, both as a prosecutor and trial judge. I believe our grand jury was 23 people, but you only had to have a quorum. And you did not have to have the majority vote. You had to have a majority vote, but not the unanimous vote for a charge.
Now, I will tell you, it's been a little while since I've gone in front of the grand jury, but I do remember those are approximately the numbers.
Okay, so Judge De La Garza's laid that out really well about the grand jury. So we'll move on from that. And the other area I mentioned was juvenile court, and really quickly on that. Juveniles are not charged with crimes. They're charged with delinquent offenses, so that's why there's no right to a jury trial in juvenile court, and those are heard just by the judge if there's a charge filed against someone.
And they're not public hearings either. They're to protect the juvenile's rights.
Right. Although juvenile proceedings can be open to the public, and it's gotten much more in that direction over the last 2 decades or so. So what about jury selection? This is a whole different topic. We talked about the 12 jurors versus 8 versus 6 versus 4. Those are the options. If you're picking a smaller jury panel of like 4 people, it's going to be a lot easier to pick a jury than if you have a 12-person jury. And it was already mentioned in Justice Court and Municipal Court, there's a physical limitation based upon the space within the courtroom and in the jury box. But one of the very important issues today is the application of the Batson case. So this was the case, Batson v. Kentucky, that came from the 1980s from the U.S. Supreme Court that said racial discrimination in the selection of a jury is unconstitutional. Not only that, it's structural error. So if it happens that the jury is not picked with a race-neutral methodology, then the whole verdict is suspect and it can be overturned, or it has to be overturned if that violation is found. And I'm wondering how any of you if you're dealing with this now. Judge O'Neill, you said it's been a lot of years since you did a jury trial. The Batson case came out a long time ago, but there's been a lot of development since then.
Yeah, my last jury trial was 6 years ago, right before I was elected, felony DUI causing death. What the courts are expanding now beyond the racial disparities are sexual preferences, prejudice against people's ethnic, religious, all of those sorts of things. If you can prove that there is a direct link between usually the prosecutor eliminating people from the jury because of a certain ethnic, racial, sexual, trying to think, religious affinity, then I think that you have a really good chance at overturning the entire verdict.
Okay, so do you recall making that objection when the jury was being selected on cases you were defending somebody, that there was a Batson violation?
Yes, I had a case involving his Hispanic defendant, and I had the prosecutor excuse every Hispanic in the jury pool. I did make that objection.
Do you recall what happened in terms of how the court handled it?
Well, the court overruled my objection, and because the prosecutor was smart and he had basically he was able to state a reason, a neutral basis for excusing each one of those people from the pool.
Okay, so it's actually a multi-step process. Judge Gall, have you seen this come up yet in any of the civil trials you've heard?
It has come up in 2 of the 3 trials that I've done, which I'm surprised that it's come up so far in a majority of the trials that I've done or I'm in the middle of. So the multi-step process, Judge Gibbons, that you're referring to is after the parties exercise their peremptory strikes, which we can discuss separately, but after the parties exercise their peremptory strikes, you can raise what we call a Batson motion, or sometimes people call it a Batson challenge, or a challenge in their JB versus Alabama, which is the corollary, I think, about gender discrimination and selecting the jury. And as the movant, you have to establish a prima facie case that the peremptory strikes were exercised in a discriminatory method or a discriminatory raise, where there's an inference of discrimination raised. And there are various ways you can do this. You can show that, for instance, the other party struck all potential jurors of X race, whereas they didn't strike, they passed on jurors of Y race, even though the potential jurors are, for all purposes similar. So there's different ways you can raise the inference, but you've got to create a prima facie case. And then the burden shifts to the opposing party to provide non-discriminatory reasons for their strikes. And if they're able to establish a non-discriminatory reason to the court's satisfaction, the court will overrule or overturn the Batson challenge or the Batson motion. In both cases that I've done so far, in the first case, I did believe that an inference of discrimination had been raised, and but I believe that the other party was able to provide me non-discriminatory reasons for why they struck the particular jurors that they did. And then in the more recent case, we're actually in the middle of that trial right now, so I won't talk too much about it, except I'll say what I put on the record, which is there was actually a question in my mind as to whether or not an inference of discrimination had been raised. But I went ahead and allowed the parties to make the argument for the record. And then I moved forward as if an inference had been raised. And then I found that there had been non-discriminatory reasons provided to me.
So that's very interesting. It's appearing regularly now in civil cases too. I'm sure you're going to face this same issue in justice court. Have you had this yet, Judge Della Garza?
We have not had that in just the 2 trials that we've had, but I did have a Batson challenge in at least one of my jury trials as a prosecutor. And as Judge Gall pointed out, it is usually raised at the point when you're talking about your peremptory challenges. And just to go back for our public and let them know, the peremptory challenges are a challenge that you are asking to strike a juror where you really don't have to give a basis. You're just saying, oh, for whatever reason, I don't want this particular juror on the panel. But if there are reasons that the judge can maybe infer, such as race or gender, then your decision to want to strike that person can be challenged.
Okay, thank you for explaining that. Sometimes we just use the legal jargon and the public won't necessarily know what we're talking about. So that makes it a little bit clearer. What about the more common issue when jurors come in and they don't want to serve on the jury and they start giving excuses? How do you handle that? Judge Gall, you've probably have heard plenty of that even in the short time you've been a district court judge.
I have. So one thing is I try to say at the beginning, I try to lay kind of the rules of the road for the jurors at the beginning. And I say, look, nobody probably wants to be here. A few of you may, but most of you probably do not want to be here. That there are many other things you'd rather be doing, including perhaps watching paint dry on a wall, right? But I thank them because it's a sacrifice to come and do jury duty. So I thank them for coming in. And then I explain to the potential jurors, look, there are reasons why you might be excused. For instance, if you have non-refundable tickets on an international trip, we're probably going to excuse you from the jury, right? If you have an undue medical or physical hardship, we're probably going to excuse you from the jury. So for instance, if you have a surgery scheduled during the jury trial, I'm probably going to excuse you from the jury. And then if you have other undue hardships, I'm going to listen to those. I mean, the hardship that most frequently comes up for me is I'm a caregiver, right? I've got to take care of my kids. I've got to take care of, my elderly parents, so on and so forth, or a financial hardship, like I work this job, I'm going to get fired from it, so on and so forth. And what I tell people is that I'm going to listen to them on their hardships, and maybe their hardships will constitute a reason for excusal. But most hardships most hardships alone will not constitute an excuse from the jury, including financial hardships. And this is the one that jurors, I think, have the most difficulty understanding. And the way I try to explain it to them is I understand if you are in a lower wage job, it is a financial hardship for you to be here. I understand that. But if we excused everyone within a certain wage range, all we would have is rich people on a jury. And we don't want that either. we want a great cross-section of the community serving on our jury. So I try to explain that and I try to set the tone, but I hear, I've heard interesting excuses. I'm sure I haven't heard them all, but I've heard a wide range of excuses so far.
All right, thank you. Judge O'Neill, what would you say to prospective jurors, either as the attorney or as the judge when they come in, why it's important that people serve on a jury?
I'd like to remind, I have to tell you, one of my heroes who has passed is a gentleman who I went to law school with, Judge Patrick Flanagan. And he had probably one of the best juror instructions that I've ever heard. And a lot of it had to do with how many people have fought and died for the right for all of us to sit in judgment of one another as jurors. And I really found that a compelling argument. The other argument that I think works for a lot of people is that if I let you off this jury trial, it's going to be it's a 4-day, pretty easy contract dispute. The next time it could be a 6-month murder trial where you're having to watch gruesome pictures and you're out of work for 6 months. So you might want to reconsider your request to get off the jury today.
Okay. All right. Very, very good points. In fact, a lawyer from Reno sent me his reasons for it, what he thought I should say, and that lawyer later became a federal judge. And that back in the pre-revolutionary days, the people living in America were denied the right to trial by jury from the king. And so the Revolutionary War was sparked for that reason, among others, if you look at the Declaration of Independence. And it's one of the few requirements that we have in our country for public service. I mean, we don't have a draft anymore, so people aren't forced to be in the military. So serving on a jury is very important. And as was pointed out by both the judges, we want a cross-section of the community in every way possible, so it's a jury of one's peers. So I would recommend everyone not make excuses. I'll give you one very quick anecdote. I was sitting in here in Clark County as a visiting judge and picking the jury, and it was going pretty well, and excused a few people here and there, and one person kept raising his hand trying to get off the jury, and I kept telling him no, and a couple potential jurors were excused because it was against their religion, and they explained why, and I thought it was legitimate, and they didn't want to sit in judgment of somebody else, so they were excused. That person, of course, that was unsuccessful in his prior request, then raised his hand and said, "It's against my religion too." Well, at that point, the lawyers looked at me and they were rolling their eyes, and we thought, well, this person really doesn't want to be on the jury and may not be a very good jury, so he was excused. But that is the exception to the rule. Do you have any stories like that?
Well, there is usually one or two people that really are trying to get out of their duty, but it is such an important thing for you to do for your community, and as you said, to serve your community and to understand how important of a right it is. If you were charged with a crime, to know that others would make the judgment rather than just one person. I think one of the things that we get in justice court, which maybe you also get in municipal court, is that we're able to tell jurors it's probably going to be a fairly short trial. And it kind of helps them to say, okay, I think I can do this for 2 or 3 or 4 days versus maybe Judge Gall in a very complex civil case. So we try and even entice our jurors in that way, really to try and make it as palatable as we can. We try to let our jurors know that we're going to not waste their time. If we can avoid doing something while they're waiting, we try and do it after hours. We try and do some things during the lunch breaks. So I know maybe people don't realize, but even though the jury might not be sitting out there in the hallway, when you're in trial, you're doing things early in the morning, you're doing things late in the evening, you're doing them over the lunchtime to try and make it a good experience and a positive experience for those jurors so that they do want to be a part of the process.
I certainly remember those 12-plus hour days when working with juries as a judge and as a lawyer and a prosecutor.
Absolutely.
So a couple of questions about what happens during trial. At the beginning of a trial, the judge always tells the jurors that they can't talk about the case amongst themselves until it's submitted to them at the end of the trial. I mean, what is the reason for that? I mean, people obviously shouldn't be talking to people not on the jury, but what about the jury? Is there something about what happens at trial as a case develops and it evolves that if you don't talk about it, you might have a more open mind? I mean, have you seen this in action, Judge Gall?
Absolutely. I mean, the mandate is that the jurors are not supposed to come to a decision, and they're supposed to keep an open mind until the case is finally submitted to them. And I think the fear is reasonably that if they're talking to anyone, and in particular, perhaps if they're talking amongst themselves, then they're not going to be able to keep an open mind. They're not going to be able to listen to all the evidence and look at all the evidence holistically after the case is submitted to them.
Okay, Judge O'Neill, what do you think about that?
I agree with Judge Gall. What we're trying to do is avoid taint. It's not lost on me as a former public defender that the prosecution goes first. And if the jurors have already made up their mind before they ever even hear your case, then you're drastically prejudiced. So I used to like to argue that when in voir dire, that please keep an open mind, because you can't jump to conclusions and make your decision on what you hear first until you hear the entirety of the case. That's only fair. And I think jurors got it.
Absolutely.
Okay. Do you want to add anything to that, Judge De La Garza?
No, I would say exactly what both Judge Gall and Judge O'Neill said.
Okay. I would just add one other quick point about the process, and that is if the jury was deliberating and a juror had to be excused for some reason and an alternate juror came in to serve, the judge would tell the jury that the deliberations must start over, that the new juror on the case has to hear everything that's already been talked about. And if you have jurors talking about the case individually as it's progressing, well, the other jurors haven't heard that conversation. And there may be something that those jurors who were discussing it missed, and they could come to a conclusion. Yet if you talk amongst the whole group, then somebody else could point out some aspect of the case that was overlooked. And if any of you ever saw the movie 12 Angry Men, Henry Fonda.
Absolutely.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Okay, that's 11 guilty. Was Bonnie not guilty? 1. Right. 11 guilty, 1 not guilty. Well, now we know where we are.
Boy, oh boy, there's always one.
So, what are we doing now?
I guess we talk. I began to get the feeling that the defense counsel wasn't conducting a thorough enough cross-examination. I mean, he let too many things go by, little things that...
What little things? Listen, when these fellas don't ask questions, it's because they know the answers already and they figure they'll be hurt.
Maybe it's also possible for a lawyer to be just plain stupid, isn't it? I mean, it's possible.
You sound like you met my brother-in-law once.
I kept putting myself in the kid's place. I'd have asked for another lawyer, I think. I mean, if I was on trial for my life, I'd want my lawyer to tear the prosecution witnesses to shreds, or at least try to.
You know, it's a good example of where that could happen, where some piece of evidence was misinterpreted and one person noticed what the problem was and was able to bring it to the attention of everyone else. So that's the short answer about why you can't talk about the case, and it's a very important rule and that jurors must follow it. So what about during a trial, just a practical problem? If it's moving slowly, jurors are getting bored, and then a juror actually seems to be nodding off or not paying attention. I mean, as a judge, I mean, what can you do? And does this adversely affect the trial? Have any of you ever seen something like this happen?
I've had a judge excuse a juror based upon the fact that and we all surmise that the juror may have been ill. but he did keep nodding off, and we had an alternate replace him.
Judge Gall?
I haven't had it happen yet. I've been very fortunate in that all the jurors in the 3 juries, including the one that's going on right now, seem to be paying very close attention. I did happen to have it happen in this last jury pool that came before me. There was a gentleman who was actually in the box, and he was nodding off, and it was revealed through voir dire that he worked the graveyard shift. And so we actually excused him for cause because he was sleeping through the voir dire process.
Yeah, I mean, it's pretty tough, and it's not fair to everybody else in the courtroom because everybody else is giving their full attention, and jurors are required to do this too. What would you do, Judge De La Garza, if you had a juror that wasn't paying attention, or even to the point of falling asleep?
I think like Judge O'Neill said, you might have to look at excusing that person, especially when you are looking at a criminal case and somebody's liberty is at stake. You want everybody to be paying full time and attention to what's going on so that this person can get the hearing that they deserve.
Of course, the corollary to that is, what if the judge isn't paying attention?
Well, we never want to see that.
Well, there is a difference, and Judge Gall, you briefly mentioned the bench trial versus the jury trial. I mean, is your focus different in a bench trial?
Absolutely. In a jury trial, I am not the fact finder. In a jury trial, the jurors are the fact finder. What I am is I am the gatekeeper of evidence, and I am the person that instructs the jury on the law. My role actually, I've told people my role actually drastically changes once the jury sits. Okay, I have a very limited role. I have an important role, but my role is very limited. And so, yes, I absolutely still need to pay attention and listen to the testimony, including to rule on matters of admissibility of evidence and so forth. But I'm not the fact finder. So it's a different cognizance, if you will. During a bench trial, the lens at which I'm looking at the testimony is different, right? Because I am the fact finder in that instance. By the way, I don't have anyone to instruct on the law at that point, other than myself. And issues of evidence also change a little bit because the law presumes that I can gatekeep the evidence that I consider in my mind.
Okay. Very well stated. So in contrast, in municipal court and justice court, the judge is almost always the fact finder. So Judge O'Neill, what do you think about that you are the only one that's making the decision on this case? Do you ever feel like, I wish I had a jury?
Well, yes, actually, I had someone run over a man and his child, and it was a very gruesome case that went to trial. And I would have not liked to have made the decision in that case. That's probably the only one I've had in the 6 years that I've been here. But unfortunately, or fortunately, we are elected to make those difficult decisions. And you have to do it. That's part of the job. Luckily for those of us in the municipal court, it doesn't happen. It's not very gruesome, and it's not very often.
Well, that's some good news. So, Judge De La Garza, we talked about you helped draft the bench book explaining to judges how to do a jury trial. How's the process differ when you're the sole decision maker in the case? I mean, do you go through a certain process?
The process is a little bit shorter and it's a little bit easier. So when you do have a jury, you have the parties making opening statements so that they can kind of direct the jury as to what they're going to be looking for. Then even in putting on their case, they might go through certain things that they know a person who's just a member of the public might not pick up on every day versus a judge that they know. And like we're talking about jury trials and me specifically being in battery domestic violence, your attorneys probably know that you listen to battery domestic violence all day long, unfortunately, so that you're going to be aware of certain facts so they can maybe go through things a little bit quicker. Same thing with the closings. You won't have that when you're doing a bench trial. And then, like Judge Gall alluded to, you don't have to instruct yourself on the law. You should know the law, although sometimes it is tough, and sometimes you do have to take a little break and go and refresh yourself on some things, unlike a layperson who really just isn't familiar with the law for the most part.
Well, we've talked about jury instructions just very briefly. I mean, what's the point of instructing the jury? I mean, do you do it at the beginning, during the trial, or at the end?
It is a very weird process in that we do it at the end. So we've had different lectures at different times kind of commenting on this, that we give it to the jury. We've now given them all of the facts, and now we say, now here's the law. So maybe would that have helped for them to have the law in the beginning to let them know exactly what they were looking for and how pieces of evidence or the facts might fit into that law? It's a possibility, but we do it at the end. Judge O'Neill, how do you feel about that? It's kind of an interesting process.
And I agree. What I used to argue is that you give them the facts and then you give them the law, and it's up to the lawyers to basically tie everything together. And that's what closing argument, that's the essence of closing argument. And obviously, as a defense lawyer, if they missed a knot or they missed a link in the chain, boy, you're the first one to jump up and let them know that the burden wasn't met or that element wasn't reached. And so that's what I see. I see it's the lawyer's obligation to link the law and the facts together.
So Judge Gall, do you give the jurors any preview about the law, at the start of the trial? And then if some legal issue comes up during the trial, I mean, what do you tell the jurors then?
So I don't give them a preview of what I would say the primary jury instructions are. There are some pre-trial instructions that I give the jury, but most of it has to do with how the trial is going to go. It has to do with that they're not supposed to talk to anyone, like we've discussed. It kind of talks about the order of the trial. But I don't, like, for instance, if it's a personal injury case, I don't give them an instruction on what constitutes negligence or what constitutes a duty or what constitutes a breach of that duty. And I actually feel that the order works very well, where we do the facts and then we instruct them on the law. And then in closing arguments, the lawyers tie everything together. And I think part of that's because we don't want juries to be overly concerned about the law during the trial process. We want them to be listening and paying attention to the evidence and to the facts. I have had jurors, and I know we haven't touched on this, I have had jurors send me questions about the law in the middle of trial. And I do not pose those questions. First of all, I don't answer those questions myself at that point. But two, even if they're posed to the witness, I don't ask the witness those questions because I wouldn't consider those legally proper questions for the witness.
Okay. So a related point is, if there's an objection during the trial, do you rule on it immediately? Do you hear argument? You send the jury out of the room? Do you wait till a lunch break? And why would you do some in front of a jury and some not in front of a jury?
So if the objection is very simple and it doesn't require argument of the counsel, I will simply rule on the objection in front of the jury. And by the way, let me clarify that. I will always rule on the objection, right? And either instruct the jury to regard or disregard. Actually, I don't say regard, but either disregard or strike. I will always do that in front of the jury. However, if there is argument on the objection, I always take that either at the bench or out of the presence of the jury. If it is going to be argument that we can do in a few minutes, I will take that at the bench, and then I will rule on the objection once the attorneys are away from the bench. If it is going to be a protracted argument, then for the comfort of the jury and the comfort of everyone, I send the jury out of the room.
Do you try to do anything to prevent delays so jurors are not sitting there twiddling their thumbs, their time is well served during the day?
I try to do everything I can to prevent delays, but unfortunately, delays in trial, I think, are inherent. For instance, sometimes attorneys do not make motions in limine ahead of time. And so we are arguing complex motions or what would otherwise be motions that were properly the subject of motions in limine. We are arguing those in the middle of trial. And of course, I have to take them. I have to listen to those arguments and I have to rule on them. And sometimes, and I think Judge Garza was saying this, sometimes there's a unique issue, or sometimes I'm not refreshed on the law on a particular issue, and I have to stop everything and I have to go research that issue. The other ways delays can result is witnesses. Sometimes witnesses are only available at certain times, and we try to do everything we can to accommodate witness schedules, but sometimes it's just inevitable that we can't, and there are delays built into trials because of that.
Okay. All right, thank you. Let's move to the end of the trial. So you've all mentioned it. The facts have been presented through the witnesses. The instructions of law have been given to the jurors. Lawyers are now able to argue their case to the jurors and why they think their position is correct. Then the jury goes to deliberate. Are there any rules for the jurors during deliberation? I mean, what they can't and can't do, and how do you take a verdict, and how do you guarantee that that's what the jurors really intended to the point where somebody can't change their mind?
One of the scariest things that I have is the age of the computer as a lawyer, and I'm sure as a judge. When you send that jury home, you want to make sure that they're not looking at Google Earth about where the accident happened or researching the law or that sort of thing. And I think you really, as a judge, have to be very proactive with jurors in cautioning them about doing any independent research. That was one of the things that always caused me a lot of worry as a defense counsel, and then as in situations where I've ruled as a judge.
So presumably the judge has strongly advised the jury that things that cannot be done, and now it includes taking no cell phones or electronic devices into the jury room. Is that correct?
Right.
So Judge Garza, what do you do to ensure the process of, you've gone through this whole long proceeding to make sure it's correctly handled at the end so no mistakes can be made and it's a fair proceeding for all?
So again, that is part of your instructions near the end when you're going to have that jury go out and deliberate. You do let them know that they should not be talking to anybody else, that they should be focusing on the evidence that's given to them, that they shouldn't be doing outside research, and that they should be having these conversations with the other jurors. The one thing that does come up sometimes is they have questions, like Judge Gall alluded to. And so sometimes you do have to deal with jury questions. But again, like Judge Gall said, you can't decide that on your own. You have to notify the parties then that there's been a question, and everybody has to come into the courtroom and you discuss whether this question is something that should be answered or not. And sometimes there's legal reasons that we cannot answer the question, or sometimes that we draft an answer and it goes back with the jury so that they can continue with their deliberations.
Okay. Thank you. So Judge Gall, let's assume you've been notified that there's a verdict. And how do you take that verdict and you make sure that the verdict it meets all the requirements of whatever the jury has to decide? I mean, we haven't talked about general verdicts versus special verdicts, but you're probably the only one here that deals with special verdicts. So what's your process? And you could briefly explain the difference there.
So we agree upon a verdict form before. I usually set what I call settle the verdict form at the same time as I settle the jury instructions. And just as a little preview, the parties may not agree on what the verdict form should be. Should it be a general form? Should it be a special form? And they may not agree on exactly what the jury should be instructed to on the law. So we settle the verdict form. The jurors go back. Once they reach a verdict, They indicate that they've reached a verdict to my marshal. They filled out the verdict form typically, and if it's a special verdict form, they filled out the questions that are on the special verdict form. We reconstitute everybody in the court, and then we have the foreperson. Right? We have the foreperson, who is the person that out of the jury members that the jurors themselves have elected effectively to be their spokesperson. We have the foreperson read the verdict after the court has reviewed the verdict and to ensure that it's in good form. So the verdict is delivered, and then what the lawyers can do, what the court can do to ensure that the verdict is correct, is they can poll the jurors to ensure that they agree with the verdict. We have in a civil case, we have the correct number of jurors agreeing to the verdict for the verdict to be entered.
Okay. So as the judge, you said that the judge reviews it before the foreperson announces the verdict. So what are you looking for on a special verdict form? And the general verdict form is like guilty or not guilty, or negligent or not negligent. So a special verdict form has questions that leads the jury to a particular conclusion. So what do you do with those questions?
So I'm looking primarily to make sure, one, that all the questions are answered, right? And then second, that the questions are consistent. And what I mean by that is oftentimes the question will say, if you answered no to this, stop. Right? Because typically you can't actually return one type of verdict or another at that point. And I'm kind of simplifying this. Or if the question says, yes, go on, that you've actually gone on. So what I'm looking for as a general matter is that the questions that have been answered are consistent with the verdict that has been rendered.
So let's say that you've approved it, the jury's polled, the jurors are asked individually, I assume, is that your verdict? And if they say yes, and you're done, you have the correct number of jurors. And now the court says you've accepted the verdict, and we will move to the next proceeding, which in a criminal case might be sentencing. In a civil case, it's going to be a judgment reflecting what the jury decided. So now the trial's over, and a juror says to a lawyer, that's not my verdict, or I don't agree with it, or something improper happened. I mean, can a court even consider that sort of information, Judge De La Garza?
Well, motions sometimes are made after the fact if something like that happens. The purpose of the polling is to make sure that that is the verdict, and that everybody had a chance to basically stand up and say, yes, that was the verdict, and that's what I believe it should be. But sometimes afterwards, a juror might contact a defense attorney and say, look, this is what happened in the jury room. This was improper. And so certain motions might be filed to go back and review the process.
Can a juror say, I that was my verdict on that day, but now I've given it more thought, and that's no longer what I believe?
I guess they could. Is that going to go anywhere? Probably not.
Okay. So Judge O'Neill, have you ever seen a verdict overturned because of something that was revealed after the trial in terms of the deliberation, how the jurors came to their decision, the whole process?
Yes, I have. I had a child sexual assault where one of the jurors didn't reveal that he'd been a victim, and but then obviously stressed that in the jury deliberation. So obviously he was disingenuous when in voir dire about his questions, and it did result in overturning the conviction.
So I'm sure that's pretty unusual, though.
Yes.
So Judge Gall, I imagine you haven't had that happen yet, but back in your days as a lawyer, as a litigator, did you see anything like this where there was a claim made about the jury process and a juror no longer supports the verdict? Something along those lines?
I never saw that while practicing. And I think my response to that, including in the civil context, is that it depends, right? So as Judge De La Garza was saying, just because a juror decides they've had a change of heart, right? That's not going to be sufficient at the change of heart. But if something tainted the jury process, right? Like, let's find out, for instance, that one juror is a hired gun for one of the parties, right? That almost certainly, depending on what happened, that's almost certainly going to lead to an overturning of the verdict. Let's find out. Let's use an example. For instance, the jurors went back into the jury room and one juror had their cell phone with them and they started Googling everything. And they influenced the verdict. Verdict's probably going to be overturned. So it really depends on what the taint is at the end of the day.
So let's say, Judge Della Garza, you were selecting the jury. It's a domestic violence case. The jurors are asked questions. Have you ever been the victim of a domestic violence? And the jurors said no. And yet later on, it turns out that one of the jurors had been. I mean, it's a hypothetical, so I can't really say what would you do with it, but how do you prevent something like that from happening?
Well, when your jurors start to answer questions, they're sworn in. And they are supposed to answer the questions truthfully. I will tell you that one of the things that sometimes happens in domestic violence is that they're kind of personal questions, and people don't necessarily want to answer them in front of everybody. So sometimes you will have a juror that says, I don't want to answer that. And instead of maybe automatically being disqualified from the jury, you might bring them in separately with the attorneys so that they have the opportunity to answer in a less public setting.
So that brings us full circle on this. We're back to the jury process, the whole point of it, to get a fair trial, a just result for all. And it requires a certain amount of disclosure, honesty, that people that they're not trying to be dishonest, but they might have forgotten something. They didn't realize the significance of it at the beginning of the case, and then later on. So is there anything that that each of you could say to prospective jurors here in conclusion about the importance of full disclosure at the beginning, and maybe doing something like Judge Della Garza just explained, where you don't have to say it in front of everyone if it's embarrassing? Judge O'Neill, I'm sure you probably had a lot of cases with some difficult facts, like a sexual assault case. And I mean, how do you get people to talk about that publicly? And
Well, it's interesting. A lot of people will come forward with that kind of information. And what I like to liken the voir dire process is a job interview. And I say to people who have been victims of, let's just say, sexual assault, and we know about that. A lot of people don't want to come forward with that information, but they want to sit on a jury. We say, if because you have this situation where you're a victim of this particular crime, you could be excused and sit in there's another trial that would be good for you. Could be a burglary, it could be a civil case, that sometimes people just aren't fit, particularly based upon their life experiences, to sit on one type of case or another. And I like to let people give them an out. So if there's a reason that they would like to sit as a juror, or feel that it's an obligation, which it is, but because of personal circumstances where they feel that they can't be fair, we just move them to another opportunity to sit as a juror in another type of matter.
All right, thank you. Judge Gall, are you willing to explore this with jurors and try to prompt them so they have full disclosure, yet they don't have to be embarrassed by it?
Absolutely. I try to emphasize to the jurors that, we want them to err on the side of disclosure, regardless of the question. We need full, honest answers, because what the lawyers are trying to do is they are trying to get a full, fair, and impartial jury for the case. And then what I try to do during the voir dire is, and this happened with my last voir dire, there was a woman who was asked a question about her hardships, and she had a medical hardship, but it became very apparent. And I think a lot of times it becomes very apparent to me when they're when the juror is uncomfortable responding to a question. And so I called her up, and I called the lawyers up for a bench conference. In other instances, I've allowed the lawyers to voir dire one particular juror outside the presence of other jurors. One other way, just very quickly, I know this is lightning round, but one thing we can consider using more of is jury questionnaires, because jury questionnaires are written responses to questions, and in my view, they're kind of efficient in a couple of ways. They're efficient because I think they take up less time overall, but two, there's a quality efficiency to them, which addresses this very question, which is people are more likely to be forthright when they don't have to announce their responses publicly.
Is that an issue you're willing to champion with the 8th Judicial District Court and the Chief Judge in particular to expand the use of jury questionnaires?
100%. But of course, we're each of the 32 judges here, kind of rule in our own little fiefdom, right? And so I don't think it can be forced upon any one particular judge, but I would certainly champion it in our judge meetings that, don't just look at the time efficiency of jury questionnaires, right? Look at the quality efficiency of jury questionnaires, because that's where I think the real benefit of questionnaires come in.
One final question here. Have any of you ever been called for jury service, or if you didn't personally serve, have a family member serve? And what did you get from that? And if not a family member, then a friend.
I was actually called for jury duty when I was working for the 8th Judicial as a hearing master, but I didn't really get to go through any of the process of even listening to the questions. I was really hoping at least to get that far, but I was excused just when they had the number of people or to go into the courtroom. So they said, we don't need any more jurors today, so you're excused. But I did sit there for the day and waited like everybody else does.
So you were very willing to do it then?
Absolutely.
You didn't try to get out of jury duty?
No, I didn't. The only thing I kind of had asked them if they could do for me, though, is could I go and listen to my calendar while I was just waiting? But they wouldn't let me, so I just, sat there like everyone else.
Would you do it again?
Absolutely. I think it is a duty that you should perform for your community.
All right, Judge O'Neill?
Yes, I was called one time to sit on a criminal case, and when the presiding judge saw that I was in the audience, excused me, so I didn't get very far. But I will tell you a sweet story. One of the earlier judges in the 2nd Judicial was Judge Foreman, and he was on a jury, and he turned out to be the foreman of the jury, and they allowed him to sit. He was just a fair guy, and everybody liked him, and so he sat as a judge on a criminal jury trial.
Wow. Would you serve again?
Absolutely.
All right, Judge Gall?
Okay, so this is sort of my Hollywood star run-in claim to fame story. So when I was a baby lawyer in New York, almost 16 years ago, I was called for jury duty into the New York State courts along with Ethan Hawke. So Ethan Hawke was in my kind of, jury pool, and I didn't actually even make it into the courtroom. They had enough jurors, but Mr. Hawke did make it in. So I got to spend the better part of the day with him. So this is actually a really good example. Everybody is subject to jury duty. It doesn't matter who you are. It doesn't matter if you're a judge. It doesn't matter if you're a lawyer. It doesn't matter if you're a Hollywood movie star.
Okay, excellent point. So I have not been called for jury duty myself. However, there was a case in Carson City where a person robbed the Olive Garden restaurant, and then he drove from Carson City into Douglas County where I was presiding, and then the police arrested him there, and there was some resistance to the arrest. So I had a criminal case in front of me related to that. But as to the robbery, my brother was living in Carson City and was the Chief Justice of the Nevada Supreme Court, and he was called for jury duty and served on the jury.
Oh, wow.
And he did not use the fact that I was also working on a related case as the trial judge. And then after he served on the jury, he ended up writing an article for the Nevada Lawyer magazine about his jury duty service and encouraging others to also serve on the jury. So maybe I'll be called someday, but there are exemptions for certain people, like if you're in the legislature or if you're over a certain age. And I don't know if I'll make it because I'm older than all of you. Well, no, I don't know. Judge O'Neill, we won't have a contest on that. But I haven't been called, and it still could happen. So I want to thank everyone who watched our presentation tonight. Hopefully you learned something from the excellent statements and discussion from all of our judges on this panel. Judge Maria Gall, 8th Judicial District Court here in Clark County. Judge Melisa de la Garza, Las Vegas Justice Court, in which department?
15.
Department 15 here in Clark County. And Judge Shelly O'Neill, Reno Municipal Court, in which department?
2.
2. And again, I'm Michael Gibbons, Chief Judge of the Nevada Court of Appeals. I feel very fortunate to be in this position, and I very much enjoyed talking to all of the other judges here tonight, and maybe back for another episode. So that's it on the jury trials. Feel free to submit your comments and questions through whatever source you watch this interview, and we'll see if we can address those in another show.